Hello, my name is Rada Costa, and on behalf of my partners, Paige Cantwell, Victoria Ferrante, Cody Merritt, and Connor Rand, I will be the narrator for our presentation, Cefaratti versus Aranow, and tort liability for the actions of an apparent agent. Our agenda for this presentation is to review the history of agency theory, the key points about agency theory from preceding Connecticut court cases, the key points from Cefaratti versus Aranow Supreme Court case, the likely effects of this opinion on hospitals in Connecticut, our suggestions for Connecticut hospitals going forward, and we will end with some brief closing statements. Hospitals operate in a volatile environment where organizations are susceptible to litigation despite the organization's best efforts to act in their patients' best interest and within the law. These hospitals will not be able to operate without the work of many physicians who, despite their hospital privileges, are not the hospital's agent nor employee. There are unfortunately instances where the actions or inactions of these independent practitioners cause harm to patients and litigation ensues, not just against the independent physicians, but also against the hospital under the theory of apparent agency. Apparent agency can be defined as conduct by an agent that causes another party to believe said agent is authorized to conduct business on behalf of a principal, whether or not that is actually the case. Connecticut's hospitals and other healthcare facilities have recently been affected by the Cefaratti versus Aranow Supreme Court case ruling on apparent agency theory. Briefly, the 2016 ruling on Cefaratti versus Aranow involved a surgeon, Dr. Jonathan Aranow, who had left a surgical sponge in the patient's abdominal cavity during gastric bypass surgery. This was done at Middlesex Hospital. The hospital argued that it could not be liable for the surgeon's alleged malpractice because the surgeon, who had hospital's privileges, was not the hospital's agent or employee. In Cefaratti versus Aranow, the Connecticut Supreme Court resolved a dispute amongst lower Connecticut courts and recognized tort liability for the acts of an apparent agent in a medical malpractice case. In doing so, the court expressly overruled a series of Connecticut appellate court decisions spanning 3 decades and set new parameters for identifying issues of apparent agency liability. In medieval times, hospitals were originated by religious and military orders. This continues through the centuries into modern times. From the late 1800s until the 1940s, the charitable immunity doctrine provided nonprofit hospitals in the United States with immunity from liability for the alleged conduct of their physicians and nurses. As hospitals grew larger and became healthcare systems run as corporations, the charitable immunity doctrine fell under attack, and lawmakers began looking for ways to hold hospitals liable based on their roles as suppliers of medical providers. The term apparent agency emerged in the 1970s as a means of binding the hospital and independently contracted physicians into an integrated healthcare delivery system. Generally, in the context of apparent agency in medical malpractice, courts held that a principal must make a manifestation to a third party that reasonably causes the third party to believe that an individual is an agent of the principal. Since its introduction to the medical world, apparent agency has been most commonly applied in situations involving patients seeking emergency treatment without taking into account the physician. For example, apparent agency occurs in the emergency department context when a hospital holds itself out to be the provider of high-quality ED services. The application of apparent agency is very similar across states. In Ohio, the case Hanola versus Lakewood led to the court holding that hospitals are absolutely liable for the actions of ED physicians because in the patient's perspective, the physician and the hospital are one and the same. Similar to the case Hanola, in Pennsylvania, the Pennsylvania Superior Court held in Capon versus Divine Providence Hospital that the role of the hospital in society makes it more likely that a patient will look to the institution for care rather than the individual physician. Most of the rulings from Hanola and Capon show that the courts rely less upon the perspective of the patient and more upon how hospitals hold their physicians out to the public. In order to understand the decision in Cefaratti versus Aranow, it is essential to understand the rulings of previous Connecticut court decisions in regards to the theory and application of apparent agency and authority that influenced the opinion of the Connecticut Supreme Court. In 1941, Connecticut Supreme Court used apparent agency to find a country club liable for the destruction of a car in a motor vehicle accident that resulted in the death of a watchman. In the case Fireman's Fund versus Longshore Beach Country Club, a member of the country club requested that a watchman, who was independently contracted at the time, retrieve his car. Tragically, the watchman drove into a basin and drowned while retrieving the member's vehicle. As the watchman was not acting within his scope of employment at the country club, the court decided he was negligent and therefore the country club was liable for the vehicle. The court held that to apply apparent agency, the principal held the agent out to the public as possessing sufficient authority, and the person dealing with the said agent had reason to believe the agent was capable and had the authority to act in such manner. The liability lies more heavily on the shoulders of the principal and their behavior before the act in question, rather than their agent. Although this case deals with a country club and their watchman, the foundation of the case's definition of apparent agency holds true in the decades leading up to Cefaratti versus Aranow. In terms of apparent agency in Connecticut, no court had found a hospital vicariously liable for the negligence of a staff physician until 1991. The case Leconque versus Elliger was the first case in the Connecticut judicial system that held a hospital liable for an independently contracted physician. Just as in the cases Anola and Capon, the court studied the relationship of the hospital and the physician as an integrated system and held the hospital responsible for the acts of their contracted physician. Leconque was the cornerstone of applying the doctrine of apparent agency throughout the court systems of Connecticut. Building off Leconque, other court cases in Connecticut provided a more solid understanding of the doctrine of apparent agency. According to the court's decision from Francisco versus Hartford Gynecological Center, the doctrine of apparent agency basically holds that one who employs an independent contractor to perform services for another which are accepted in the reasonable belief that the services are being rendered by the employer or its servants is subject to liability for physical harm caused by the negligence of the independent contractor in supplying the services to the same extent as though the employer were supplying them itself or by its servants. Francisco versus Hartford was an extremely important case in the Connecticut judicial system because it provided a clear definition of what apparent agency is. In Francisco versus Hartford, the court held that a hospital can be held liable for the acts of an independent contractor if the hospital was negligent in their actions. However, if the plaintiff had consented to the treatment with the understanding that the surgeon was not an employee but rather an agent, it would be more difficult to find the hospital liable. To understand the potential repercussions concerning the outcome of this case, we must first get an understanding of the procedural history. On August 20, 2003, the plaintiff, Lisa Cefaratti, met with Jonathan Aranow, employed by Shoreline Surgical Associates, in regards to treatment of her diagnosis of being morbidly obese. Following consultation and examination, Dr. Aranow recommended that the patient undergo gastric bypass surgery as her course of treatment. On December 8, 2003, the patient underwent the recommended gastric bypass surgical procedure. Over the course of the next several years, the patient had multiple follow-up appointments with Dr. Aranow, and she alleged that approximately 1 year following her surgery, she began to experience pain in her abdominal region, comparing the symptoms to having something caught in her ribs or carrying a child in her chest cavity. According to the plaintiff, she described these symptoms to Dr. Aranow at every one of her follow-up sessions outside of the initial 2. On August 6, 2009, following a diagnosis of breast cancer, the patient underwent a computer tomography scan of her upper body. What this scan revealed was a foreign object lodged into her abdominal cavity. On September 9, 2009, the patient was informed by Dr. Aranow that the foreign object was a surgical sponge, which was then removed, at which time the abdominal pain ceased to be present. On August 18, 2010, the plaintiff brought a medical malpractice lawsuit against the defendants. Named in the suit were Jonathan Aranow, Shoreline Surgical Associates, and Middlesex Hospital. The suit, with a complaint amended on November 30, 2010, alleged that Dr. Aranow was medically negligent in his treatment of the plaintiff for leaving a surgical sponge in her abdomen following the surgery performed on December 8, 2003. That Shoreline and Middlesex were directly liable for their own negligence, and that they were also vicariously liable for Dr. Aranow's negligence. On October 1, 2012, Middlesex filed a motion for summary judgment, claiming that they could not be held liable for Dr. Aranow's alleged negligence and resulting malpractice as Dr. Aranow was neither an employee of the hospital nor an agent, but merely had been granted surgical privileges. The Connecticut Superior Court granted this motion on April 29, 2013. The plaintiff appealed the Superior Court decision, but on December 9, 2014, the Appellate Court affirmed the trial court's decision. However, the Appellate Court affirmed that decision on the basis that said precedent prevented the use of apparent authority and cannot hold the principal liable in a tort action for the actions of any alleged agent. The case reached the Connecticut Supreme Court, which used the opportunity to examine the principles of agency theory and their application to medical malpractice. While the plaintiff alleged that the doctrine of apparent agency applied to this case, Middlesex Hospital claimed that plaintiff was confused with apparent authority, and the case should be thrown out under the precedent set that the state has rejected apparent agency as a basis for tort action. In order to adjudicate on this case, the Supreme Court began by examining the two doctrines in question. While apparent authority affects the actual agent acting under the authority of a principal, apparent agency is applicable to a person who was never an agent of a principal for any purpose. Under their analysis, the court determined that at this point the two definitions had merged. Under their new interpretation, the singular doctrine is as follows. Apparent authority is the power held by an agent or other actor to affect a principal's legal relationship with third parties when a third party reasonably believes the actor has authority to act on behalf of the principal, and that belief is traceable to the principal's manifestations. Under this new interpretation, it falls to the principal to clearly establish that there is not an agency relationship in the public view. The next argument that the Supreme Court looked at was whether or not this theory of apparent agency was relevant in tort actions as opposed to its traditional use in contract actions. While Middlesex argued that because it had never been applied to tort actions, the Supreme Court determined that the case Fireman's Fund versus Longshore Beach Country Club, ruled on in 1941, did establish the ability of apparent agency to be actionable in a tort liability. As such, the only remaining question was whether or not there was an actual apparent agency relationship established between the defendants. In creating their new standard, the court determined that the plaintiff must still prove a detrimental reliance on the alleged apparent agency when they made the choice to utilize the services of the agency, specifically Dr. Aranow in this case. In order to do so, the court created the requirements that the plaintiff prove three elements. First, the principal held the apparent agent out to the public as having the authority to perform the services in question, or the principal knowingly permitted the apparent agent to act as if they had the authority. Second, that the plaintiff knew of these acts by the principal and actually and reasonably believed that the agent or apparent agent possessed the necessary authority. And third, the plaintiff detrimentally relied on the principal's acts. The Supreme Court acknowledged that proving all three elements would be extremely rare, saying in the opinion that it will be the rare tort action that the plaintiff will be able to establish the elements of apparent agency by providing detrimental reliance. This decision was not an easy decision for the court, coming down to a 4-3 vote. The dissent was written by Judge Zarella and presented two arguments. His first issue was with the reading for the preceding cases, determining that the actions of the court in Fireman's Fund versus Longshore did not decide on the fact that apparent agency was applicable to tortious actions, because that question was not relevant to the issue at hand in the case, and was thus not ruled upon directly, only assumed. Their second issue with the majority ruling was a separation of powers issue, with Judge Zarella stating that the impact of this decision will have a far-reaching effect on the healthcare industry within Connecticut, and that because of this, the court is not in the position to have access to enough knowledge to make a decision that is in the public's best interest and would have such wide-reaching public effects that this was more appropriately would fall into the wheelhouse of the legislature. With the establishment and adoption of a new standard, the court determined that for fairness, the case should be reheard utilizing this new standard. As such, they reversed the appellate court's summary judgment and remanded the case back to Superior Court to be adjudicated with this new standard in mind. The Connecticut Supreme Court created two alternative standards that plaintiffs can follow in order to prove tort liability based on the apparent agent theory. Each of these standards will have implications for hospitals, and in order to better understand how this Supreme Court decision will affect Connecticut hospitals, we interviewed Ruth Cardiello, the Vice President of Enterprise Risk Management and Chief Compliance and Privacy Officer at Stanford Hospital. This interview offered us the opportunity to learn from a hospital executive whose responsibility is to decrease the risk of liability for the hospital. The following is her interpretation of the standards and their consequences. The first standard generally involves non-employed physicians or independent groups that are contracted to staff hospital-based services. For example, radiology, emergency department, pathology, anesthesia, and on-call non-employed physicians. In this first standard, the patient must prove the hospital held itself out as providing certain services, the plaintiff selected the hospital based on its representation, and the plaintiffs relied on the hospital to select a specific person who performed the services that resulted in harm. The immediate outcome is that this Supreme Court opinion has now increased the risk of liability, and hospitals have become excess carriers for contracted groups and on-call non-employed physicians. According to Mrs. Cardiello, the hospital will ask all contracted independent groups like anesthesia and ED to increase malpractice policy limits to $3 million per case and $6 million per year. The hospital will also have to ask hematology, oncology, pulmonary medicine, and other medical groups that have a physician service agreement with the hospital to also increase their policy limits by the same amount. This will cost groups anywhere from $100,000 to $300,000, and they may balk at the request. Since Stanford Hospital is self-insured, Mrs. Cardiello, as representative of the hospital, will have to educate and reassure the reinsurer market regarding the plan to increase limits on contracted groups. Nevertheless, these reinsurers may raise hospital premiums to cover for the increase in risk. The most worrisome outcome is that this opinion will apply to all open cases involving contracted groups and not just to new cases that arise after this opinion. The hospital now will have to increase reserve for all these previous cases. The second standard involves non-employed physicians who are part of a specialty service such as a bariatric surgery center, breast cancer program, or a hernia center. This is a standard the plaintiff in the Cefaratti case will have to meet in order to prove tort liability based on the apparent agent theory. In the second standard, the plaintiff must prove the hospital held the physician out to the public as possessing the authority to engage in the practice at hand. The plaintiff knew of these representations by the hospital and believed the physician possessed the necessary authority. The plaintiff detrimentally relied upon the hospital acts and would not have dealt with the physician if they knew the physician was not the hospital's agent or employee. The immediate outcome is that this standard can lead to the hospital now becoming the excess insurance carrier for independent physicians who they hold out as part of the team or as part of specialty services. According to Mrs. Cardiello, the hospital will now have to review all electronic and print media for how Stanford Hospital represents independent physicians on Stanford Hospital's public domain, collateral material, and public relations. The hospital will also have to review independent physicians' web profiles and other media content to determine whether there is additional exposure and evaluate the need for contractual changes, increased limits, and indemnification clauses. All marketing materials will need to have a prominent disclaimer regarding the relationship between the hospital and the independent physicians. In conclusion, the Connecticut Supreme Court opinion in the Cefaratti v. Aranow case will increase hospital exposure in cases where only the non-employed physician is negligent and will increase the likelihood of being named in a suit with the non-employed physicians. This opinion will also change settlement dynamics because plaintiffs will no longer feel the need to settle for their physicians' policy limits. Physicians will be less likely to settle because of the diminished concerns about a verdict in excess of their insurance coverage, since now anything in excess will be covered by the hospital. The hospital excess insurers will pressure the hospital to increase their reserves in order to settle cases before they need to get involved in any payment. While other state Supreme Court rules only hold up in their own particular state, we suggest that Connecticut hospitals study the outcome of suits in other states related to agency theory for further guidance on how to proactively distinguish independent contractors from their employees and avoid liability due to apparent agency. Attorney Roger Clayton, a partner of Heil, Royster, Volker, and Allen, and chair of the firm's healthcare practice group, provides suggestions for hospitals as to reviewing cases based on apparent agent theory. The following suggestions by Attorney Clayton increase communication and transparency between the hospital and patients about who is performing different aspects of their care, therefore helping protect the hospital from apparent agency. First, all marketing and advertising materials, including language, pictures, testimonials, and other references, must not imply that independent contractors are employees. An example of language that should be avoided would be referring to independent contractors as, quote, our physicians, end quote. Second, there should be standards in place within the hospital to ensure that medical staff and independent contractors are visually distinguishable. This would include the scrubs, lab coats, and name tags worn by employees and non-employees. The hospital's logo should be avoided on the uniforms of non-employees. Third, consent forms play a large role in increasing the strength of a hospital's defense against apparent agency. This disclaimer should not be in small print or placed between other parts of a contract, but rather be its own section within the medical paperwork. Informed consent and treatment forms should include a disclaimer which informs the patient that independently contracted members of the medical staff and other non-employees are not agents of the hospital. And last, the hospitals may utilize the posting of signs throughout the hospital, effectively acting as public disclaimers, notifying patients that some of the medical practitioners operating within the hospital are independent contractors and are neither agents nor employees of the hospital. In doing so, for non-emergent situations or other cases where obtaining informed consent is not an issue, hospitals may be able to mitigate the risk of exposure to apparent agency liability. In conclusion, the Supreme Court of Connecticut recently issued an important decision that could significantly increase a hospital's liability for the negligence of physicians who have privileges but are not directly employed by a hospital. In Cefaratti v. Aranow, the court resolved an issue that had resulted in conflicting decisions in the lower courts and held that the doctrine of apparent agency can apply in medical malpractice actions to hold a hospital vicariously liable for the negligence of a person whom the hospital holds out as its agent or employee. In Cefaratti v. Aranow, the Connecticut Supreme Court's opinion created two standards, but it did not rule on the merits of the case. The choice will be up to the lower courts to apply these standards as cases come up to the court system. The standard that applies to contracted groups will present difficulties for hospitals because of the implied hospital-physician relationship and a patient's inability to choose a different physician, especially in emergency situations. The second standard will present difficulties for the plaintiffs since they will have to prove that they would have made a different decision if they had known the physician was not an agent of the hospital. This opinion is problematic for hospitals because of the extent to which hospitals are capable of controlling medical care. Any contention that they can control minute-by-minute medical care is far-fetched. Unfortunately, there are also added benefits for litigation. Plaintiffs will have greater monetary awards if hospitals are found liable for the actions of physicians, because juries tend to find liability against institutions more easily than against individual physicians. The decision of Cefaratti v. Aranow will have repercussions for hospitals in Connecticut, placing them in a more tenuous position concerning liability than ever before. With this decision being so new, hospitals should begin to take proactive steps to mitigate the potential effects of an apparent agency issue that could arise in the future. On behalf of Team 8, we hope you found this presentation educational, and we thank you for watching.